Hello, huh, ma'am.
Good
Yes,
morning.
sir.
I
Good
think we
morning.
can start.
Okay, sir. Thank you so much. Safura,
एक
you
दो
may
मिनट
start.
रुको मैडम, एक दो मिनट रुको।
Okay, sir. Okay, okay. Safura, wait
एक
for
दो
2
मिनट।
minutes.
हाँ, कुछ लोग गा
Okay,
रहे
sir.
हैं।
Okay. Okay, sir.
मैडम शुरू करो। करते मैडम। गुड, गो अहेड।
Pleasant afternoon to all. I, Ms. Sheikh Safura, a student of BLLB 4th year, on behalf of ML and GE Societies, Manikchand Pahade Law College, extend a warm welcome to each and everyone to this online workshop on intellectual property rights, patents and design filing, in association with Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. Before we begin, all the participants are requested to kindly keep your camera and microphone off for better experience. Starting off by thanking our speaker for today, Dr. Bharat sir, and our principal, Dr. C.M. Rao sir, the president of this workshop, and all the participants for making an effort to connect with us today. Very foremost, let's begin this workshop with the most significant part of our programs, that is the recitation of preamble. During the recital, the participants are requested to remain silent. Preamble, the Constitution of India. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thoughts, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Moving ahead, I would now call upon our faculty member and the teacher coordinator of this workshop, Dr. Sheetal Barhate ma'am, for giving us a brief overview about this workshop.
Thank you, Safura. Respected chief guest of today's workshop, Dr. Bharat Joshi sir, Assistant Controller of Patents and Designs, Rajiv Gandhi National Institute of IP Management, Nagpur. President of this function, Dr. C.M. Rao sir, Principal of MP Law College. Vice Principal Morris sir, IQC Coordinator Dr. Aparna Kotapalle Madam, faculty members, and dear participants. Good afternoon to all. In the beginning, on behalf of ML and G Society's Manikchand Pahade Law College, I welcome you all in this workshop on IPR and patents and design filing organized by this institute in collaboration with the Rajiv Gandhi National Institute of IP Management, Nagpur, as a under the National Intellectual Property Awareness Mission. Dear participants, every year we organize workshop on IPRs. We have organized IPR workshop in collaboration with DPIIT, IPR Chair, Gujarat National University, CIPAM, then Patent and Design Office of Kolkata. This year, we are not only this, we have also organized one international webinar on the IPR. This year, we are organizing this workshop in association with the Rajiv Gandhi National Institute of IP Management, Nagpur. This workshop, it is intended to acquaint participants on the fundamentals of IPR That is what exactly mean by the IPR. What about its classification, that is patents, designs, copyright, trademark, GI, and more importantly, our today's resource person will be guiding us about the procedure for the filing of patent and designs. Total 364 participants have been registered for this workshop from all over India, consist of law students, assistant professors, researchers, and advocates. I hope this that every participant join this workshop shall be benefited after hearing the discourse of our today's resource person. I take this opportunity to express my sincere thanks to all the office bearers of Rajiv Gandhi National Institute of IP Management for consenting and for associating with us for having this collaborative event. More importantly, I am thankful to Dr. Bharat Suryavanshi sir, who is instrumental for having this IPR workshop. I am also grateful to all the respected members of MLNG Society, Principal Sir, Vice Principal Sir, IQC Coordinator, and faculty members for always supporting us to conduct such a events. And with this brief introduction about this workshop, I will stop here. Uh, I thank organizers for giving me this opportunity to express few words about this workshop. Thank you so much. Over to you, Sakura.
Thank you so much, ma'am. Proceeding ahead, it's now time to introduce our today's resource person. Well, it's a privilege to have with us respected Dr. Bharat Suryavanshi sir, a person with extraordinary accomplishments and a true talking about his education and working experience. Dr. Bharat sir completed his secondary education from Jawahar Navodaya Vidyalaya, Bidar, Karnataka. He then pursued his post-graduation in biotechnology from Gulbarga University, Karnataka. Later, sir has got his MPhil completed from the same Gulbarga University. Sir has accomplished his PhD on the topic bioefficacy and phytochemical studies on medicinal plants of Kinwat and Mahur forest of Nanded district from Swami Ramanand Tirth Marathwada University, Nanded. Currently, Sir is an assistant controller of patents and designs. He has an experience of more than 20 years working in the central government office under the Patent Office, Ministry of Commerce and Industry. Further, Sir has also published various national and international papers. He was also deputed for training at Tokyo, Japan for examination and IPR issues. Bharat Sir has been associated with various judicial, national, and international training programs regarding IPR practices. Last but not least, Sir had also delivered landmark decision by rejecting the Pfizer patent application for arthritis drug which was filed in India. So, your presence today reflects the immense support and encouragement you extend to the cause of spreading awareness about intellectual property rights. Once again, on behalf of MP Law family, I heartily welcome you. We are indeed grateful to have you with us today, and of course, looking forward to hear from you. But before that, all the participants, please take note that following this lecture of Dr. Bharat sir, we will have a two-minute Q&A period. During this time, you may send in your questions using the chat box below, and we'll try answering your questions. Now, without any further ado, I humbly request Dr. Bharat sir to kindly address the workshop. Over to you, sir.
Thank you. Thank you so much. I also welcome you all for the IPR session. I'm very thankful that Dr. CM Rao ma'am has conducting this program. Really proud moment. Intellectual property awareness is very less in our India. It's our duty being a law college. You are all knowing what is intellectual property, even though to making people together and to share the information is very important. So wishing you all the best. I try to understand, make you understand how to file the patent application by giving first brief about the different kind of intellectual property rights. Let us see in detail by sharing the slides. Are you able to see my screen, anyone, please?
Yes, sir.
Yes, sir.
First of all, I introduce my office where we are working. Our office is called as Office of the Control General of Patents, Designs, Trademark, and Geographical Indications. You might have knowing we are having offices at Kolkata, New Delhi, Mumbai, and Chennai. We are having training center only one in India, that is Nagpur. We are having trademark offices in addition to four. One is at Ahmedabad, Gujarat. Geographical indication office at Chennai. These are the pictorial view of our offices. This is our training center. This is our website. If you are not aware of IPR, please log on to this www.ipindia.gov.in. Again, we are keeping updates on social media accounts also. Please go through that. Let us see today's topic. What is intellectual property? You can see my slides carefully. I shown something blooming in the mind. It means I want to convey you that. I want to say you that the product of mind is called intellectual property. Now the question arises, what is product? Any idea which arises from your mind, that is an intellectual property. If you are developing design for computer, it's a design decision. If you're developing technology, then again it's patent. If you're writing books, novel, stories, again in the form of copyright. So any kind of idea that arises from your mind is called intellectual property. For example, in December 2019, we heard about the coronavirus. At that time, we are not having any vaccines. Not only we, throughout the world, there was no vaccine for that. But scientists all over the world started to carry out the research, like Pfizer company, many institutes, universities, and in the middle of 2020, we got Covaxin, Covishield, and Sputnik. What is that again? It's an idea. It's an intellectual property arises from the human mind. You know, human is the intelligent animal in the animal kingdom, having power of thinking. Therefore, we are taking a lot of challenges. We went up to Chandrayaan 3. We got many solutions for many treatments for many diseases. Day by day, we are improving in the field of technology. So simply, I can say the product of mind is called intellectual property. Now, let us see how that idea arises from the human mind. When you are in the classroom with your professors and discussing on a particular topic, trying to solve some problems, sitting alone or in a group of people and discussing on a particular topic and give the solution for that. Therefore, the property that arises from human mind or a product of human creation is called intellectual property. For example, you know, everyone is having two-wheeler, four-wheelers. We are going to the petrol pumps. Day by day, the rates are getting higher. You can check the 2014, 16, 18, now 21, 23. Why? Petrol is not a renewable source of energy. Now, somebody among us or any biotechnologist, any scientist is trying to give solution for that. That is a process of making biodiesel. So he's trying to solve some problems, alternative problem, that is in biodiesel. So idea is arising from human mind. Therefore, the property that arises from human mind is called intellectual property. Did you know? Austrian company has developed smart shoes. For whom? Blind people. There was a problem in the public domain or in the public, how the blind people can walk. We have seen the walking with the sticks, but how much distance they can cover, what is the obstacle in front of them. But by using this technology, they can detect obstacle up to 4 meter away, means how much long distance. Easily they can walk. There was a problem, somebody is solving that. Therefore, any problem, if you are giving solution by your intellectuals, that's in technology, you can get patent for that. Again, one of the professor from Nagpur, Dr. PC, has developed cold drinks from moa flowers. You know, moa flowers earlier used to make only liquors. Now preparing cold drinks. What is this? New idea arising from your mind through his research. You are given as a solution, that's in cold drinks from the moa flowers. Again, tree climbing machine. Earlier, you know, South India, the people who want to pluck the coconut tree and coconuts from the tree, it's very heighted. They used to climb by very this thing and getting tired. So somebody has developed scooter for time that. Water walking shoes, water pumping, all these are examples of technology we can get patent for that. Let us see what is the background of intellectual property. The property means our mind directly goes to the tangible form of property and we say, I'm having car, gold, plot, flat, even land in my native, so I'm rich enough. But there is another kind of intellectual property that is industrial property and copyright, which we cannot touch. That is an intangible form of property, like patents, designs, copyright, trademark, geographic indications, layout of integrated circuits, protection of plant varieties, protection of trade secrets. So all these counts are the different kind of IPRs. Now you know what is IP, but how to define? Everything is required definition for that. We can say intangible means we cannot touch the creations of whom? Human intellect. Having commercial value, asset like any other form of property. Means Occard company of Aurangabad is developing some vaccine or any medicine for cancer, then they can license to Serum Institute of Pune for more production and they can get money out of that. Therefore, that is an asset for them. They can do, you don't think plot, flat, you're getting money. Even for the intellectual property, you're getting money back. So it's an asset like any other form of property. We can say IP is an exclusive right. Somebody is filing patent on your name or on his own name or college name or company name. They are having the right, not with brother, sister, or anyone else. Therefore, we can say it is a negative right. Other person cannot exercise the power of that, except the applicant can exercise the power. Therefore, we can say it's a negative right also. Again, IP is an territorial right. Once you are filing your technology, your patents in India, it's valid only in the country of India. If you want to establish your rights in other countries like USA, Japan, Germany, or any other country where you want to do your business, then you are supposed to file your application by means of two-way. One is called PCT, Patent Cooperation Treaty. Another is called by means of conventional application as per section 135 of the Patent Act. So that you can get right in those countries, or you can stop them from selling or production of your product or process in those countries also. Again, it's a licensable right. It means you can license to anyone whom you want. As if you're developing any product, then you can license to anyone. Bajaj company of your Aurangabad is producing some scooty, new kind of something. Then they can license to other company like Tata Motors or any other company who are involved in the business of that. So, whom you want to do license, you can license. Right is with the applicant. What is patent? Exclusive, monopoly privilege or rights granted by the government to the patentee for 20 years from the date of filing or priority for commercial gain, not to keep it in file record. When you're disclosing everything clearly, then only you're getting the right as an territorial rights. Because one of the requirement that is section 10(4) of the Patent Act says you should define invention clearly and sufficiently, then only you're getting the right. Because once the patent expires, anyone can use that and they can practice it. Therefore, all the clear information should be there in the application. We are doing the research, PhDs, MPhil, projects we are carrying out, but still we don't know we are doing research in the form of invention or discoveries. Discovery means finding or exploring something which is already in the nature, and discovery as such no technical act. For example, rubber in the nature, just scientists have isolated this and discovery, but somebody is making tire from that. It's an invention because he's putting his effort to solve some problem. It's an invention. I'll quote another example. We know I'm taking project for the isolation of microorganism from Occard company of Aurangabad. So I'm taking the sample from that company effluents, isolating the bacteria, but the process of isolation, I'm changing pH, temperature, media, my own process creating. So you can get patent for that, but not for the microorganism which I'm isolating, because I know that effluents is having some microbes. Even daily effluents of our houses are having some microbes. But genetic engineeringly, if I'm modifying that genetically modified microorganism, I can get patent like oil-eating bacteria, example. So we should understand while doing your research or a project, whether my research topic is qualifying the definition of invention or not. If it is invention, please go for the patent filing before the publications. Now, the invention means it should be product or process. Product means what? ATM machine. It was not there in before 2003. Now we are having its ATM machine product. CT scan machine product. Process of making medicine is a process. Process of making shampoo is a process. It should be useful to all. Again, it should be new. It should not be obvious. I'll tell you in next time what is obviousness. Again, it should not be in the public knowledge before the filing date. Even law people publish the papers. While publishing the paper, we check whether my research paper, whether my article which is written by me is not in the public domain, in the international journal, national, or in the paper. If not, then only I'll go for the publication. So you should know whether my research is new or not. If it is qualifying this, definitely it's an invention. It is qualifying the definition of invention. Please go for the patent filing. Simple example I'm taken to make you understand. In 1980, 81, 83, 85, when I was a student in the small village, I was not using this sharpener. We used to use the blade for sharpening the pencil. But now, LKG onwards, people are using the sharpener. What is this device, tool, machine invented by one of the scientists? You may be doctorate, but you are not inventor because you have not got any patent on your name. So C.A. Busher was this. Again, we know in the school level, general knowledge, we have studied who has invented electric bulb, who has invented aeroplane, who has invented vaccine. All we know, first time who brings the technology, get the patent, they are called as inventor. Like famous patent for this bulb Alva edition. This for telephone. Can anyone tell me, because from this example, I want to convey one message to you all. Therefore, you have to guide me to understand this example. Can anyone tell me? You can unmute yourself and you can tell me. This device you can see in the old movies of Marathi, Hindi, many more places. So this device was there. We used to speak in the foreign country also, even though someone got idea to develop the mobile phone. So what was necessary to develop the mobile phone? What made him to develop the mobile phone? Anyone please? Dear professor, student, anyone can. Why someone has got idea to develop the mobile phone or to bring the mobile phone? Yes. Because this device is having some disadvantage. Yes, proper communication. Somebody tell Abhishek. Activity. Yes, Mira. Yes. Yes, mobility. Yes. See how you are thinking, how you are putting your comments, because you are thinking innovatively. Sabse hatke. Kahitari vegla you are thinking from that. So you are something doing new. If you would have thought earlier, you would have also invented something new. Yes, we can carry anywhere you want. Yes, you are right. So all these are input coming from your side. It means you are trying to think on the particular subject. You are trying to think on a particular topic, and you have to think, then only you can achieve something. Those who know the history, they can create the history. So you know something means you can do something. So I'll tell you, this is having some disorder that I cannot this telephone from my cabin to Rao sir's cabin or ma'am's cabin, because it is connected at a particular point. If someone phones comes, they have to run to the router's cabin and they have to speak. One of the disadvantages. Again, if you want to dial, you might have seen the old movies. 10 times I have to dial. Ring, ring. It time consuming. To solve that problem, someone thought and they brought the table phone, wherein I can dial tak 1, 2, 3, 4. But again, I cannot change this telephone from router's cabin to somebody else's cabin, because again, it is connected at a particular point only. Therefore, after that, someone thought, modified, we got cordless phone. We can take in the hall, kitchen, and drawing room. But I cannot take in the meeting, nor in the car, nor in the jeep, nor in the plane. To solve that problem, someone thought, and we got the mobile phone in India in the year 2000 or 2002. Students may not know, but the professors are knowing. Simple Nokia was there, silver color, very heavy, and more than 5,000 rupees was the price of that. But now, 500, 1,000, 2,000 up to 40. What is this? Improvement of technology from AG bell to mobile phone. Only incoming, outgoing were there. Now we are having video calling facility. Google Meet, Zoom Meet, WebEx. What is this? Improvement of technology. So from this example, I want to communicate to you one message that getting patent is not difficult. If you are improving your technology in your own field, for physics, chemistry, biotech, micro, electrical engineering, any engineering, if you are improving your technology, you can get patent for that. For example, I'll take another example of which is in daily need use or whenever we need that we are using. You know, everyone is knowing paracetamol is in tablets. Whenever someone has fever, our parents says or we say, please take the paracetamol. But you know how much it takes time to reduce your fever? It takes 6 to 8 hours to reduce your fever. But I am from Occard company as a scientist developing improved formulation of paracetamol. पहले तो paracetamol है भाई, but I am developing again improved formulation. Filing the patent, I am proving that my paracetamol is reducing your fever within 2 hours. What is this? More therapeutic efficacy, more activity, more effective clinical trials. Then definitely no one can stop you from getting the patent because you are showing the more result. So please improvement in yourself, in your own field, definitely can get patent for that dependent. I'll quote another example to make you understand again. You know, daily we are using shampoos. Somebody use Vatika, somebody use Clinic Plus, somebody is Dove, somebody is Mama Earth. Nowadays, people are using Wow shampoo. Are they really curing your dandruffs? Some heroines are giving advertisement and you're using that. Even somebody is working on medicinal chemistry or biotechnology, they can also come with improved herbal shampoo for dandruff. No one can stop you from getting the patent, but you are supposed to prove good result than Vatika, good result than Sunslick, Dove, or Mama or Wow. Then definitely you can also get the patent. So getting patent is not difficult. You should be result oriented. Or if you're developing any new machines. Earlier, X-ray machine was there. Now we are having CT scan machine. Improve result. Doctor used to say you are having lung infection. Now they can say you are having 5 score, 6, 7. What is this? Improvement of technology from X-ray to CT scan machine. So I want to convey you that any improvement in the technology, you can get patent for that. Again, you know, Bluetooth was not there earlier. Now you are having. Nano car in between came. So it's invention and technologies. Louis Pasteur, rabies vaccine. All these are invention technologies. Rabies, these are drones, smart card, mobiles. All these are inventions. We can say patents that you can get technology for that. Let us see another kind of intellectual property called design. Design means shape, configuration, pattern, ornament, or composition of lines. You know better than me as you are all law. But you can see I have taken simple example Bajaj Iron Box. You can check my this Milton Chuck new design. You can check my spectacle, watches, mobiles, anything which looks beautiful, that's design. Flush design, brush, car, even handle design. The term is 10 years. It can renew for every 5 years. Total 15 years term for the design. You can get right for that up to 15 years. Even set of articles like cup set, sofa set, chair set, spoon set, you can get registered in the government of India. Even this sanitizing machine, newly registered. You go, these are the different design. This syringe you can check. This syringe different. This ampoules, this different. This medicine, this. So anything which looks beautiful, that's some design. How it works, how it functions, we don't bother. Earrings, bangles, curtain design, bedsheet design, all these designs are different. You can check. You can check my watch, simple Timex. You might have some other watches, the design is different. Daily consumer products, comb, office bag, wallet, pen, pencil, Whirlpool fridge, LG fridge, IB washing machine. When we are students in the small village, Even in the universities, when we are doing PG, we used to go for poha pakoda because very less amount used to be with us. We have to manage in that. But now you are going for Coca-Cola, Maaza, Sprite, many more places like pizza. But you never think or thought that why pizza bottle is Maaza bottle is like that, why Sprite bottle is like this, why Coca-Cola bottle. You never think because that the company of the particular name was registered by their own, so no one can copy the name. Rail water, Aquaguard, Aquafine water bottles even different. Even Sennheiser bottle design is different. Kolhapuri chappal is different. So these are the designs. Say configuration pattern you can get registered in the government of India. You know sharpener, but dual in nature, new design. You know pencil, but peacock and parrot facing something new design. These are the new designs. Dress designs. Even this design was developed on a student of National Institute of Design, Ahmedabad, while doing their project. And why you and me are not getting the idea to develop such kind of design? Can anyone tell me why someone has got idea to develop such kind of design? Yes, please comment or unmute. Unmute and comment, or you can chat in the chat box. Why someone has got idea to develop such kind of design? Why can't you and me? Yes, labor effort. Yes, very good, Abhishek. Less efforts, yes, reduce the weight. Yes, yes. See how you are thinking innovatively. The persons who are working in the construction company, they are carrying daily on their head stones, bricks, sand, cement. They are having neurological disorders, as we know, nerves connection we are having. Back pain, disc pain. To solve that problem, to make easier, somebody thought and he has given this design. You can get, if you think, you can solve it. Really, a lot of thank you for activeness in the classroom. Let us see another kind of intellectual property called semiconductor integrated circuit. Electrical, electronics people, physics people are knowing what are these. These also you can get registered. We are using Taiwan, China chips. If these are new, originally when you can get registered in the government of India, you are having 10 years right. You can sell it and get the benefit out of that. Even you know what is trademark or brand. Visual symbol, which means word, name, brand, numerical or combination like Tata, Bata, how they are registered. You know, many companies like IC, Wockard, Ranbaxy, Biocon of Bengaluru, all these are registered marks. Protect the innocent public from buying the goods of second-hand party. You know, Pond's powder, how long we are using, but many of us don't know the spelling of that. Somebody says POU, somebody says PON, somebody says apostrophe S. If you know the exact name, you will be never be cheated in the market. Adidas shoes, if you go to mall, 4,000 rupees. If you go to Mumbai Bhendi Bazaar, 200. Because they are changing the spelling of that or mark of that, and they are coming the second-rate quality. You can use R Encircleation registered trademark. TA means they have applied for the mark yet to get the permission. Once you are filing trademark application, then you are getting published examination, they are getting some report of that. You have to reply for that. You may get opposition if it is similar, then opposition postings are there. You have to complete all. If you are able to solve opponents all the problem in the hearing, like a court hearing, then you are getting registered. Then you can use R N circle. Otherwise, your mark remains TM. You can check many products written TM also. There are different trademarks, collective marks, certification marks, all you can see. Dil Mange More, Adidas, Bureau of Indian Standards. All these are different kind of trademarks. Let us see another kind of intellectual property called geographical indication. Place names used to identify source of origin, quality, reputation, or other kinds of products. You know, grapes of this Nashik, Busawalचा banana, वायगावची हळद, दार्जिलिंग टी, मकराना मार्बल राजस्थान, कांचपुरम सिल्क साड़ी, Mysore silk saree, Ratlami shiv, Rasgulla Bengal and Oriya, Vidri paintings, many are there. Even agriculture products, Magai Pan, Devanali Pamelo, Kurg oranges, many got GI. Let us understand what is copyright. Copyright is a bundle of rights, covers a lot of things. It protects right holders to restrict unauthorized copying, reproduction of original expression, literary work, movie, music, painting, and so on. You know, one of the movie in Marathi, De Dakka picture, Makrandanas was a hero. In that, he has done one part that's technology, they got paid in for that. Sham Sundar Roy, Telugu movie dubbed in Hindi, they are right about the copyright. What happens if you infringe the copyright? 3 Idiot, one of the movie, that's hero is having 427 patents. So term of this is life of the author plus 60 years, depend upon the work. If you are writing books, novel, stories, autobiography, poem, anything literary works under section 2. If you are doing artistic work under section 2C, dramatic work under section 2H, musical works under section 2P, sound recordings under section 2XX, cinematography is under section 2F. So each kind of work you're getting protection in the copyright. Another kind of intellectual property called trade secret. Some invention, data, information cannot be protected by any other means of IPs. Therefore, they're keeping agent secret or confidential. Like if you're having any idea relating to new inventions, survey method, manufacturing process, experimental results, chemical formulas, recipes, financial strategies, any database. If you want to keep secret, you can keep as a trade secret. No one can ask you. You are drinking Coca-Cola, Maja, Sprite, but you don't know the formula of that. What is that? Trade secret. Another kind of intellectual properties, that is protection of plant varieties and Farmers' Right Act. Many of the companies like Jalna, Sitaljit, Bioseeds, Mycoseeds company, they're developing new varieties, but they cannot get patent for that, but they can get right for the protection of plant varieties under the Farmers' Right Act 2002. If they are novel, distinctive, if you're having unique feature and stability, definitely they're getting protection. Bidders can get, farmers can, university, even agriculture institute can get right for that. The term for the annual uh, annual crop is 15 years. For trees and wine, 18 years. Jagannath Kamtagi, please don't send these annotations to on the WhatsApp. I've taken simple example to make you understand how we can protect your intellectuals. This symbol, very famous. You can say it's an apple, though it's a trademark. Display the technology of putting inside, we are getting that's a technology, we can get patent for that. User manual of this laptop, you can get copyright for that. Inside the circuit, that is integrated circuit. So single product, we are protecting with patent design technology. Therefore, other company like Dell Computer or Samsung, this cannot copy the technology of Apple. Therefore, all are in the market, they're getting their own benefits. Way of protection of the particular technology, design, layout of circuit, even their books, how to, or instructions, how to use that laptop, we can get protection in the government of India. You can check mobile, Nokia, Samsung, all are getting protection. Let us see what are the career opportunities for the students who are listening my lecture. If you want to come in the government of India as an examiner of patent and design, you should have MS in chemistry, biotechnology, microbiology, physics, or any branch of B, depend upon the vacancy and advertisement. There are 2 papers. One is objective, another descriptive. If you qualify government job in the government of India. If you want to come as an examiner of trademark, GR copyright, you should have law graduation. Means all law people are eligible for this. You have to apply for that. Others, you can become patent agent if you are science graduate. Every science graduate can write patent agent exam. 2 papers, one is objective, another descriptive. If you qualify, then Viva OC. If you qualify, that also you are getting one number from the government of India, that is patent agent number, and you can practice law. You can work as a mark agent if you are having law graduation, copyright law agent if you are having law graduation. You can work in litigations in the courts. You can work in the IPR cell. IPR policy of central government, state government, MNCs, or everywhere you are having the opportunity. You can work in the NGOs who are helping to file patent, design, trademark application in the government of India. Or there are many IPR firms, even Aurangabad is having some IPR firms. Nasik is having, Mumbai is having, Delhi having, Nagpur. You can check in the Google. I cannot take the name being the government servant. You can work in the firm also. Now, as I told you, you may be scientist, faculty, students, but you are not an inventor. If you want to be an inventor, you have to solve simple problem by simple approach. Identify some problem in your own field, solve that problem, you can get patent for that. For example, I know problem with the bat, mosquito catching bat. Everyone is using very common example I'm taking because you are not in you may not have a science background, or some may have also. So I'm taking simple example. Mosquito catching device, or we can say bat, very common. We use in the home. But If you observe or not, I don't know. If you putting it on knowingly, unknowingly, it gives small shock to us if you touch on that. So we may not bother, but children will cry for that. To solve that problem, I am trying to use digital mosquito catching bat. What is that? You know, you are entering the mall, doors are open automatically. What is that? Digital. So if the mosquito passes through the bat, it gives shock. But if I'm to that, it never gives shock to me because it's digital, they recognize human hand. So I'm solving the problem. So definitely I can get patent for digital mosquito catching bat. Or if you're developing herbal medicine for cancer, till today there is no cancer medicine in the herb. So you are giving Ayurvedic medicine for that. So it's a new invention. So any problem you are solving, you can get patent for that. To get the patent, how the research should be. What is the requirement of that? As per section 2(1) of the Patent Act 1970, what is patentable? Section 3 says what is not patentable. So it's very long. I have to go, but it's an awareness program. Just I'm going in brief. To get patent in India, all process and products are getting patent. They should be new, having inventive step and capable of understanding. These are the three requirements to get the patent and should not fall under category section 3 and 4, which is not patentable. Like apparatus, machines, device, even chemical products are getting patents in India. Now, when we can say that your technology, your process, your device is new, when it should not be published in India or elsewhere for the novelty or throughout checking the world. It should not be anticipated. It should not be in the prior public knowledge. It should not be claimed in any specification in India or elsewhere. Then, if you're not published, then definitely we are saying that your invention, your technology, your process, your product is new. You are qualifying the definition of under section 2(1) of the Patent Act as a novelty. And there is requirement of inventive step under section 2(1)(j) of the Act. What is that? Feature of invention that involves technical advancement as compared to the existing knowledge. As I told you, AG bell to mobile phone. What is this gap? Technical advancement. Or having economic significance. Earlier mobile is of more than 5,000, now 1,000, 2,000. What is economic significance? Or both. And that makes invention not obvious to a person skilling that. I told you what is obvious. I'll tell you next slides. Obviousness means we say while speaking, making idli, very obvious. Making tea, very obvious. So let us see what is obviousness. I'll quote one example. A process of making tea comprising steps of A. Taking cup of add water, comma, adding cup of milk, comma, boiling it and adding pinch of tea powder and sugar as per the taste. Boiling and filtering my tea is ready. But as I am from Maharashtra, I am adding in second claim process as claimed in claimant, wherein one of the ingredients lemon grass in the tea or kavlacha mulya, that is roots of some medicinal plants. I am in the tea. Same process the person who is making tea in the Karnataka, but he is adding ginger for the tea. Same process for making the tea in Gujarat, but they are adding cardamom for the tea, ilaichi. The person who from Andhra or Telangana who comes for the conferences in Maharashtra, Gujarat, Karnataka, he saw the tea, he tasted the tea. It's very obvious to him make the tea by using lemongrass or gauticha or kavlacha or ilaichi or ginger. So to get the patent, it should not be obvious. It requires some experimentation, then he can arrive. And who is the person skill in that? For example, if I'm filing patent for medicine, any person who is pharma is a person skilled in the art. If I'm filing a patent on digital mosquito device, any computer fellow is a person skilled in the art. If I'm filing my patent on cars and all, any mechanical person, it should not look obvious to them. Then you are qualifying the definition of inventive. Third requirement is it should be made or user generated, like surprise result you should give, solution to a long-standing problem, fulfilled of a long-felt need, all if you are giving, definitely you are qualifying the definition of inventive. Third requirement is it should be made or user generated. So these are the requirement for patent filing. Let us see now how to file the patent application in India and who can file. As per section 6, any person, individual, natural, foreigner, any legal entity, company, Indian or foreign, or MSME, or educated, uneducated fellow, anyone can file the patent application. There is no age bar limit nor educational limit. How to file? Directly you can go to your jurisdiction, you can file physically, or you can sit in the college, home, anywhere you can file online. Since July 20, 2007, we have given online filing facility. For example, you are from Maharashtra, Aurangabad, so your jurisdiction is Mumbai. Mumbai covers state of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, Union Territories of Daman Diu, and Dadra and Nagar Haveli. So all these should file in Mumbai only. Examination may be carried out throughout the country, but only filing through your jurisdiction. What are the documents required for filing? Covering letter indicating the list of documents. Form 1, wherein applicants all details are required. In that paragraph 12 has to sign by all the inventors who are helping to carry the research. Their name you have to put as an inventor. Form 2, provisional or complete application. Provisional means the idea today it's in your mind, you are writing and filing, that's called provisional. Complete means after completion of research, you are filing the patents after completion of your whole research with the claims. Claims is the main heart of the invention. Form 3 is for the foreign filing details. Which country you are filing, what is the status of that country, you have to mention in Form 3. Form 5 to add the inventor who are helping to the research. Form 18 for request for examination. If you are filing online, pay the fees online. If offline, pay the fees offline. Fees given in the website, even though I will tell you 1,600 for natural person, 8,000 for others up to 30 pages. More than that, per page individual 160, company 800. More than 10 claims, 320 for individual, 1,600 company. This is the online filing fee. As you are teaching institute, you are having 80% fee concession for the all teaching institute. If you want to file offline, 10% in addition to the fees, what I have mentioned in this. You can check again. Request for examination is 4,000 for individual, 20,000 for the others. मी lecture मध्ये आहे. Again, Form 9 for early publication. If you want to publish early, you can request. Otherwise, no need of doing that. If you want to get patent very soon, expedite examination as per Rule 24B. Form 18A is must. While filing PCT, if India choosing an ISA means International Searching Authority, IPA means International Preliminary Examination Authority. If you are choosing as an India while filing PhD application, then you can file expedite examination. Or applicant is startup, or as per 2019 rule, one of the applicant in your group should be ladies, or government organization or institute can request for this. Fees is 8,000 for individual, 60,000 other you can get patent within 1 year. Again, this is some timelines you have to keep in mind. Provisional to complete 12 months. Request for examination 48 months. Reply to FER 6 months. Form 3 every 6 months. Form 5 within 1 month. If you want to withdraw your application within 15 days. Hearing submission 15 days. Pre-grant anyone can file before the grant. Post-grant within 1 year from the date of publication of the post-grant application. Only interested person can file. Pre-grant anyone. Here in post-grant only interested person. Now the question arises, what is interested person? For example, Occard companies develop some medicine, then Biocon of Bengaluru or Serum Institute of Pune can file post-grant because they involved in the same business. They are called as person interested. These are website. If you want to know patents, design, trademark, GI, you can click here. If you want to know copyright, click here for filing also. If you want to file online, comprehensive e-filing. For patent, e-signature or digital is required. For design, only digital required. For trademark, only digital signature. If you want to search whether your technology, you want to go to public search. Then you can search, you can check for that. Now let us see how to file the design application. Any person, as per section 544, anyone can file the design application. For natural person, fee is 1,000 rupees. Small entity 1,000, startup 1,000. Other than that, 4,000 fees for the filing of the design application. Here you have to fill Form 1 with the full name, legal status, nationality, address for service in India, which class your design is. We are having classification of the design. Advice for service in India. Priority data if you are having. Prior registration if you are having. Signature and two set of presentation you have to prepare. Power of attorney if you are going through advocate or agent. Prior document if you're having. Assignment if you're having. If you're startup or MSME, Form 24 you are supposed to file. We are classifying your design, what you are filing into 32 classes in the 237 subclasses as per the classification of goods rule 10. Locarno classification system version 13. If you are claiming the design for foodstuff class 1, if you are claiming for travel goods like suitcase, briefcase class 3, musical instrument like harmonium class 17, printing devices class 18. So which class you are? Medical equipment class 20. Pharmaceuticals class 1. So you have to classify your design. If you fail to classify correctly, we correct you when you file the applications. You have to write how your design is new. That is 1 or 2 pages. Claiming the teapot, you can key name of the college. Total numbers of 8 like front view, back view, side view, top view, bottom. All the views you have to key. You have to say how your teapot is new. Name of the applicant or agent or lawyer you have to put here. So this is the way of filing the design application. These are the bad quality of the design because no correct visible picture of that. How teapot is clear and how these are seen. It's not clear. So this is the quality of the design. Let us see what is the role of patent system or IPR. Increasement or improvement of technology day by day because of IPR we're getting the improved version. Like X-ray was that we got CT scan machine improvement. Earlier medicines were something, now we have got improved medicine of higher version. Devices also providing reward as an exclusive right for display. If you are filing patents, you are getting the right. Design, you are getting the right. Making profit, earning royalty into putting the invention into practice. Don't keep patent for the file record. It has to work like Sony TV, Samsung TV, Apple Mobile. How they are getting benefit, you can get the benefit. Then only you can fulfill the requirement of intellectual definition like intellectual property is an asset like any other form of property. Transfer into public property after expiry of term or once patent is seized. What to do now? You came to know about the different kind of intellectual property rights, how to file, what is the importance of that. So don't wait. Share the benefit of patent system in school, colleges, universities, even in the public, where you will get the opportunity to share that. Utilize the resource through organized R&D activity. Capture the market judicially like Sony, Samsung, how they are captured since TV, now LED form, still they are in the market. Earn the profit through protected market only. If you are doing something new, don't come directly. First go to protection of the government of India. If you design, get protection, then come in the market. If patent, get file, get protection, then in the come in the market. Then no one can copy it. So earn the benefit through protected market only. Thank you. Any questions we'll take now. Please share the feedback link in the chat box so that you will get the certificates. Ma'am, please share the
Sir, I will
feedback.
be sending. Yes, sir, I will be sending that.
Yes, dear participant, any questions? I'm very happy to answer the questions.
There's a question.
Yes, please. Fill the link. Neither you or the moderator nor myself is responsible for that. Please. Yes, ma'am. Any questions? Read anyone?
So, how do emerging technologies such as artificial intelligence pose unique challenges to current patent systems?
So, you know what is AI? Machine learning apparatus. Many are coming updated. They are filing the patent. Now we are, our IP law has to deal with that. But now we are dealing such time. Many patents have been filed in the India on the artificial intelligence because all the work are being done with the using software and machine based languages. So still, as such, we are not giving a patent, but we are putting this type of inventions to the parliamentary level. Let the if rule comes, we have to give the patent for such, or we have to do amendments that is like the office of the government of India. If they decides, if they like software as such, we are not giving patent in India. Method of treatment we are not giving. So let us see what the but today, as you say, it's a very emerging field, and we are getting lot of challenges to solve such kind of problems. Next, please.
Sir, next question. What are the grounds for refusing patent grant?
Yes, there are many grounds. In pre-grant, A to F grounds are prior publication, prior knowledge, until. So please check the section 25(1) for pre-grant. Check the section 25(2) for the post-grants. So prior publication, prior public knowledge, many are there. 25 A to F. So those are the grounds which we can uh, uh, refuse the patent application or revoke the patent application.
Next question. How much time does it take to get a patent after applying?
Yes. Now earlier it's much time taken. Now 18 months per publication, 6 months is the waiting period. Within 22, 18 plus 6, you are getting the patent. Sometimes if you get the opposition, then it may be delay. Or if you are requesting for early publication, it will be soon. If you are requesting for expert examination, even within 1 year also. There are different cases if you are requesting, depend upon that. But normal 18 plus 6 months is the time period for getting the patents.
Someone asked, what is the impact of artificial intelligence on intellectual property?
Lot of impact is there yet to come in the practical life, because all which we cannot see. Natural persons, you and me to file the patent. If our AI is filing the patent, now whom you are getting the right? So it's a discussion matter, debate matter. I cannot answer correctly.
All right, sir. Next, how does cyber squatting affect the trademark being an intellectual property?
See, in trademark also it's affects a lot, cyber, but there are many chances to register the trademark. Being a law, once you are filing the trademark application, we are sending the report, even you are having chance to oppose. So anyone is copying your mark or similar mark, anything if they are, you can come in the opposition and you can stop them from using your mark or name or any similar type of that. So it's right is with the individuals or company, they can come and they can resolve their problem.
Next question. Within how much period design get registered?
Design required today you are filing, if everything is okay, within 1 or 2 months you are getting such type of design also register. Usually 6 months is sufficient time to get your design register if there is no objection. If your objection, you are getting the reply for that, you have to reply, then depend upon the queue in the reply objection. We are always following the queue. You can check the status online also. Who is the controller for that design? Who is the examiner for that design? You all will getting knowing about the status of your application.
Last question, sir. Someone asked, can I register innovative business model if just want to sell to someone? Can I do it?
See, business model as such not come under the patent, because you have to explain what is construction feature of that if it is a business. If business as such comes under the copyright, you can go for the copyright of your business.
All right, sir. Thank you so much for such insightful lecture on IPR. It was truly amazing, sir. Moving ahead, now I would like to invite our respected principal, Dr. C.M. Rao, sir, for delivering the presidential address. Over to you, sir.
It gives me immense pleasure to say a few words on this particular insightful workshop on the basics of IPR and patent filing. It is our privilege to have Dr. Bharat Suryavanshi sir as a resource person on this occasion, to have an idea of what is IPR and what are the things that is connected with your future career. It is a step towards the profession. When you are joining the profession, everybody thinks that it is only a practice in the court. Apart from that court practice, there are other things which are available for your future career, where you can work as a patent agent to register the patent or protection of copyrights and IPR rights. So earlier days, there is a mindset of the people that only civil or criminal. But nowadays, the new horizons of legal field is also giving a wide platform for the embedding lawyers, budding lawyers, to get a lot of opportunities to develop not only in the field of advocacy, but also in other areas where you are interested. On behalf of the management staff, I congratulate the coordinator for arranging such an insightful workshop for the benefit of students, which is a regular practice on our platform, online platform. And it is also a wise advice by Dr. Suryavamsi that in a meaningful manner, in a simple language, he explained all the details relating to IPR related areas. Once again, I thank the organizer and also resource person for a wonderful, insightful academic feast for the benefit of our students. Thank you, one and all.
Thank you so much, sir. Thank you. Well, with this, it brings us to the end of the workshop. Hence, I request our faculty member and teacher coordinator, Mr. Shiv Kumar, sir, to propose the vote of thanks. Over to you, sir.
Good afternoon, everyone. As we come to the conclusion of the workshop on intellectual property rights and patents and design filing, it is my pleasure to deliver the vote of thanks. At first, I would like to thank Rajiv Gandhi National Institute of Intellectual Property Management for their constant support throughout their event. I would like to thank our resource person, Dr. Bharat and Suryavanshi sir, Assistant Controller of Patents and Designs, for his wonderful lecture. I am pretty sure that the participants would have found this session particularly informative. I would like to place my appreciation record for our respective principal, sir, Dr. C.M. Rao, for his presidential address. I'm also grateful to our vice principal, Mr. Sri Krishna More, sir, IQAC coordinator, Dr. Aparna Kotapalle, ma'am. I would also like to thank our coordinator for the event, Dr. Shidal Barate, for providing us with the introduction and the significance of the workshop. At last, I would like to thank the management, that is the Marathwada Legal and General Education Society, for their constant support in encouraging us to conduct such seminars and workshops throughout the academic year. I would also like to thank our respective faculty team, non-teaching staff, and also I would like to thank Ms. Sheikh Safura for her wonderful anchoring. Thank you.
Thank you, sir. Thank you. In the concluding note, I would like to take this opportunity to extend my gratitude for making me a part of this workshop. Got acquainted with many new things today, and truly it was an honor connecting to you, Bharat sir. Once again, a big thank you. Also hoping that all the participants enjoyed this enlightening workshop. Important notice that a feedback link has been shared in the chat box below. Participants are requested to kindly go through it and do the needful. Now, with the permission of our principal, sir, I hereby declare that this workshop, okay, we will click a group photo. Browser. Please on your camera. All right.
Thank you, dear all. Have a good day.
Thank you so much. Thank you for joining.